that, if you're no longer here, then do you want to make everyone's life as easy as possible, as difficult as possible?
Thank you guys for joining our episode of Money Talk. So we're here with Keith from The Will Guide. So you mind giving yourself a little introduction?
Yeah, thank you. Thanks for inviting me here today. And really good to speak to everybody about a subject matter that is very close to my heart. So The Will Guys. So we've been operating for about 15 years now. We felt that there was a gap in the market for accessible, affordable advice, and I think people had got to a point where they were fed up with sort of speaking to stuffy solicitors and will writers, and they needed some jargon-free conversation with somebody that could actually talk in a language that they understood. So that's really what our focus is on. And my journey with the Will Guys started as a client. So I was originally a client, so I was an accountant, and then when my eldest daughter was born, I wrote my first will and got to know Darren, who founded the business, and I ended up retraining and coming to do the same thing.
Oh, wow, that's great. It's been really inspiring then. So let's go through a little about how this is going to go. We're going to go through some common questions about wills to give you guys all the information, and then we're going to do a little bit of a live Q&A. So if this spurs any questions for you, or if you've already pre-submitted a question, we're going to go through that. And I want to start with a little bit of an icebreaker first. I want to know if you guys have a will, or if you've thought about writing a will. If you wouldn't mind leaving a little bit of a comment, that would be great, so I can know a bit more about who's watching. So no, but I think I should. That's probably why you're here, no? It's true. I actually personally don't have a will, but I'm hoping this is going to show me why I should.
Yeah, absolutely. And I'm sure there'll be people who are dialing in who have thought about it, because one of the most common things I get from everybody is, this has been on my to-do list. We've been thinking about this for years. It was up on our to-do list. It fell down the bottom.
Yeah.
And this is a real common theme. So I'd be very surprised if that's not what a lot of people are thinking at this point.
Or you've got someone who's saying they're changing our will.
Okay.
Yeah. So if you have any questions, just drop them and we'll be sure to answer them at the end. So we're going to go into the first question here, which is a segment really about what is a will and why do you need one? So
what is a will?
What is a will? So I'm breaking it down simply for you.
So it's a legally binding document that effectively expresses the wishes of the deceased. So what the will is doing is you nominate executors to effectively deal with your estate, and you nominate the beneficiaries who you want to benefit from your estate, and it's that formal document that allows people to deal with your affairs when you're no longer here.
Yeah. So next question is, kind of that, what happens then if someone dies without one of these wills?
Yeah, so there's a process. So it falls into intestacy. So what it means is that if someone dies without a will, there's a set pathway as to where your assets will be distributed. So, for example, if a husband died and he was married, the first 322,000 of his estate would go to his wife, and then if he's got children, anything above the 322,000 would be split 50-50 between his wife and his children. And if he doesn't have a wife, doesn't have kids, it will then look for his next of kin and just keep following down.
And that's just like flat what happens to anyone.
Yeah,
have over 322, then all of it would get left to your spouse,
and then half 50% each to spouse and kids, etc.
Yes.
Which, without going into too much detail, can make things very tax inefficient. But you don't. It means that you can't dictate who you want to benefit from your assets, and also, leaving. That's what happens. And one of the biggest problems with this is that it creates a problem for the people that you leave behind. Mm-hmm. So the overriding reason for writing any will is that if you're no longer here, then do you want to make everyone's life as easy as possible, as difficult as possible? So if you want to make it as difficult as possible, you're not going to write a will, because everyone's going to have to start jumping through hoops, and somebody's got to appoint themselves the administrator, and they are having to do a lot of work which they wouldn't have necessarily needed to do right at the point where they're grieving. Mm-hmm. It's like the worst possible time. So that's what happens.
Just making it a little bit easier for your family.
100%, yeah.
So This is another good question here. Do you only need a will when you're older, or should you be thinking about having a will when you're younger?
Yeah, I mean, I get this. I understand why some people are thinking, oh, I don't need a will.
Yeah,
Got no
got nothing.
kids,
Yeah,
or I don't own a house,
nothing.
etc.
Yeah,
But
you need a will.
I mean, I think the one things you've got to consider are, so anybody who's got an estate over £5,000 is potentially subject to probate. So you've got to go through the process. Okay. Now, you might be young and only have some money out and no one else, but if you don't have a will, that will go to mum and dad, and you might want it to go to mum and dad, but you might think, well, mum and dad don't need it. Maybe it could go to my sister or my brother or my friend or charity. And you might have personal possessions that you own that you would like to gift to somebody individually. You might have some jewelry, some items of sentimentality, etc. So, it isn't just about being old. You can be young and own property. You can be young in a relationship with somebody and not married. And, if you don't write a will and something happens to you, your partner's going to get nothing, so you might not want that to happen. So there are lots of triggers for writing a will at whatever age.
Yeah, indeed. And so you kind of answered it there. Can you make a will if you don't?
Yeah. So yes, you can. Absolutely. Lots of people, there's lots of reasons for writing wills. If you rent, but your parents have a child under the age of 18, you put guardians in a will, because if you've got children under the age of 18 and something happens to both parents, the children will go into foster care, and the family courts will then decide who brings your children up, which may not be who you wanted to bring your children up. So, if anyone's got children listening in under the age of 18, that's like one of the top 3 reasons why people write wills. And it's the reason why I wrote my will. It's when my daughter was born, because somebody told me that, and I was like, I need to write a will. I need to get it done. So, there are lots of reasons why you write wills other than property.
Yeah. And you touched on it a little bit there. We kind of went over it. You kept mentioning this word probate, process of probate.
Yeah.
Would you mind just briefly explaining what that is?
Yeah. So somebody dies, and then the executor will administer the estate, which I know we'll come to, and they will effectively apply for a grant of probate. And once the grant of probate has been agreed, then all the assets can be distributed to the beneficiaries effectively. It's the process you need to go through. Going back to, if you don't write a will, it's a different process. So you would be an executor, you would be an administrator.
I'm here with you struggling with a Samsung phone, but keep going.
You'd be an administrator, and you go through a different process. Yeah. It adds complexity, adds time, potentially adds cost, etc. So, probate is the process that wills often have to go through.
I see. Okay. So let's move on to the next session. And does anyone have any comments or questions about that? Please drop them in the chat. We are looking at the chat so I can see if there's any messages. So what goes in a will? We're going to go into that a little bit. What can you include in a will besides the money, besides the property? Obviously, you've just mentioned you can decide what's going to happen to your kids if both parents aren't there. Are there any other common things that you see in a will?
Exactly. So you can gift items to people. So you could say you could own a pet. You can say, well, if you're not here, I want my pet to go. My dog, my cat, etc. I had a client who had a duck, wanted their duck to go somewhere, which is quite unique.
That is extremely unique.
There is,
don't just set that duck free.
Exactly. There's people who have art, jewelry, football memorabilia comes up, shotguns might come up, licenses, etc. Literally, like anything, watches. Predominantly, a will is made up of property, cash, shares, ISAs, etc. That's kind of like your main investments. I said, but you can, all your possessions are going to add to the value of your estate, and you can distribute them how you want. Cars, watches, so everything really.
Everything. So nothing gets left out, basically. No. Anything you want to pass on, you can pass on with your will.
Yeah.
So what happens if someone is left out of a will, or if a family member wants to challenge it?
Yeah, absolutely. So if someone's left out of a will and wants to challenge it, so there are specific people who can challenge a will. There's something called the Inheritance Act 1975, and effectively what it means is if the people who can really contest a will are children who have been excluded, spouses who have been excluded, partners that have lived with somebody for 2 years or more, i.e. they're not married, but they've lived with that person for 2 years or more,
I see.
they can
Okay.
potentially contest the will as well. So a lot of it will boil down to, is the person contesting, what are the reasons why, were they financially dependent on that person? You know, was there something that, are they going to be worse off, by actually not being left what they've been left, etc. So, so they can contest it. They can. It's called Larks versus Negus. It's case history, and effectively they can contest the will. They can take it to court, and they can take it that far and see whether they can benefit from a greater share of the estate.
Is it something that could be worked out within the family?
Yeah, it absolutely is something that can be worked out. So a lot of these cases will either, a lot of, like when people are excluded, there are real strong reasons why. So if I ever do an exclusion and leave somebody out, there is a detailed record as to why. You can't just do it because it's a bit emotional and there's no real thought through process. But if you're getting divorced and you're excluding your spouse, that's an understandable reason. If you're estranged from your child, it's for a period of time and there's a lot of history behind that, then you can put the exclusion in. If it's a argument that you've had with your son 3 months ago and you want to exclude him, that's really not appropriate. Because it's just a shorter time, too short a time frame. But yes, they can contest it, but you have to be really careful because nobody wants to die and then everybody go to court. Nobody wants that to happen because you don't want it to leave a storm.
And I suppose that is probably where you come in with the family advice and kind of giving them the direction of, is this a problem you want to create for your family, or is there an easier way to do this?
Exactly, and that is what we do as well. And there are different ways of doing that in terms of the estate planning, but the exclusions are not taken lightly.
Yeah. There you go, good news, kids. So what is an executor? Is another one of our questions. And what do they actually do? You've mentioned it a little bit.
Yeah.
Having an executor for your will.
So the executors.
Executor. I keep using that word.
It's like I hear it all the time. It's like I don't even back in
Oh my goodness. Executor.
An executor is not an executor,
no,
by the way.
No Henry Bates around here.
So the executor is effectively the administrator of the estate. So they are going to sort everything out. Like somebody passes away, the executor picks up the will. They're like, right, what do I need to do? I might need to register the death, ring the bank and the mortgage company and the investment companies and work out what the deceased assets were at the time of their death, submit a return to HMRC, apply for grant of probate, effectively follow the process through. Their job is to effectively abide by the deceased wishes. So they are the first port of call. So, somebody just needs to be organised to be able to go through a process of getting things done.
So, sorry, now I actually have a question. We didn't go through this before, but I hope you don't mind me dropping this in. Is there a set process? Say you become the executor of someone's will.
Yeah.
Do you have a process to follow that's been given to you?
No, you don't. We'll offer some support. We don't act as executors ourselves, but we do offer executor support. So sometimes clients might just need a starting point, like, where do I start with this? And we can, have a conversation with them for an hour or two, and then that is often enough.
Yeah, to get them on their way.
Yeah, and with it,
you don't have to do it by yourself.
No, and there's a lot of you can find what to do quite easily.
Yeah.
If people are nominated as an executor, the one thing they always need to understand is if you're nominated as an executor and you haven't got the time, or you feel that you've not got the skills to do it, you don't have to be it. You can go to appoint a professional. It's not like it's something bestowed upon you that you can't wriggle out of. It's something that you can pass on to a professional if you feel that you can't. But
and I imagine at a time like that,
and that might be due to if you're not time rich or it's a complicated estate, etc.
Yeah. So where are we now? So who should you name in your will?
Well,
who should you name in your will?
Who you want. It's your will. You can put whoever you want.
Anyone?
You can put whoever you want in your will.
Even if you're not related to them?
Yeah, you don't. It doesn't have to be family. Yeah. You nominate will. You can choose who you want to benefit from your estate. Obviously, going back to the point of exclusion, it might create problems further down the line, but you can. It's your will. It's your choice.
Yeah, you go.
So you can choose who you want, whether it's family, friends, charities, etc.
Yeah. That's good news. So how do you start? So if you want to write a will, how do you actually get started now?
Okay, so start writing will. Can I just say, please don't try and start it yourself. So
a little note and put it in
a DIY will, right? So I hear sometimes people will say to me, that, oh, Bob down the pub said that if I'm no longer here, it'll all go to my wife anyway.
Yeah.
I'm like, fine, okay. And Bob down the pub's a plumber. So if Bob's ever going to do some work for you, just say to him, Bob, I'm not going to use you because I've seen a YouTube video of how to fix my burst pipe. And do you know what? I'm going to do it myself. And what's Bob going to say? Bob's going to say, no, you need a professional. So
I'm out of the job.
Exactly, but you need a professional to write a will. It's the most important legal document that you're ever going to have, and the cost of trying to fix it if you don't get it right is huge because you may not even be able to do it. So yes, if you're going to write a will, go and seek a professional and speak to them and go through that process. It's the only way to do it.
So you just said it a little bit. Do you need a solicitor?
No, I'm not a solicitor. I'm a will writer. The will guys, we aren't solicitors. Some of us have the same qualifications as solicitors. We are highly trained, etc. But yes, you don't need a solicitor to do it.
You just need a professional.
Yeah, exactly. So you just need somebody who understands and can talk you through your options, can advise on everything that you can do, not tell you what you have to do, to say these are the options for you, and it's your decision as a client to agree with what you want to do, which is what I do. All my appointments are based on you could do this and you can do this and you can do this, and I'm going to tell you all the positives, the advantages and disadvantages of all these options and what the benefits are, etc., and how much it will cost, and you're going to then make a decision.
But a knowledgeable decision.
Yeah, exactly. Yeah.
We actually have a kind of question that's a bit similar that might be a bit relevant here,
Okay.
and it's to do with the executor.
Okay.
The executor.
Yeah.
So is an executor usually a family member or is it a solicitor? So could you have? We know you have a family member as an executor.
Yeah.
Could you have a solicitor?
Yeah, so you can have both. So we will generally most states aren't hugely complicated, right? So they just aren't, like estates generally aren't overly complicated. So a layman could potentially be the executor. So what we do with our clients is we would say, who do you trust to do this? And they might choose their brother, their sister, or their friends, etc. We will then say to them, the executor has powers to be able to appoint a professional if they don't have the time to do it, or they feel that they haven't got the sufficient experience or knowledge to be able to deal with it.
Yeah.
And we have partners that we work with who can act as executors, trustees for our clients, who we can introduce to, and they can have a conversation with them, and they can decide whether they want to include them from the outset or whether they want to just have them as somebody that the executors can potentially use in the future. But we give you the flexibility. Rather than just saying, right, we are going to do that and charge a fee, it's almost a case of, you have the opportunity to do this because the estate is one property and some bank accounts. And you know what? You could probably do that. But if you don't want to, you can go and choose somebody.
Good to know. Hope that answers your question. So here's another one here. Oh, what are the biggest mistakes? We have kind of covered some of these, but what are the biggest mistakes people make when making a will?
So doing it yourself, the biggest mistake, obviously. Not thinking it through, i.e., not giving it careful consideration because, we're dealing with your assets. This is the property that you've worked for, the money that you've worked for, the investments that you've worked for. It's protecting your partner, your children. There's a lot of precious things to consider here. Yeah, exactly. So you need to take it seriously. Not seeking advice, and not giving it the consideration that it really, really needs. Because every appointment that I do, without fail, my clients will go, "I've never thought of that," or "I've never thought of that," or "I've not considered that," because it's more than just leaving a property to your spouse or partner and then it will go to the kids when you're both gone. There's a whole host of things to think about: care home fees, the later life planning. making sure the money's not frittered away by young children. If my partner remarried and I was no longer here, how do I protect my estate for my children rather than it getting lost in future divorce settlements? There's a whole loads of things to consider here, which I will talk through with everybody.
Really good point. So how easy is it then to update your will? Obviously, we've spoken about how fluid your life is and how your assets change. So how easy is it to update it? And where do you access that will? Where do you actually store it to make those changes?
Fine. So when we write wills, we give our clients two options. We can either store your will for a nominal annual fee, and it's like a fireproof, secure facility.
Imagine you've got red lasers.
Or you can store it yourself. Now, if anybody ever says to me that they're going to store the will themselves, I'm going to go, have you got a fireproof safe that's attached to your wall, etc.? Because, if there's, because you want it safe and secure.
Yeah.
So that's how it should be stored. You really should take the storage seriously because, if, say, for example, there's a house fire and your will was destroyed, it doesn't matter that there's a photocopy of it potentially somewhere else. It won't go through probate. It will be rejected. So it is easy to amend. So an amendment with our storage, if you store wills with us, you effectively get a free annual amendment. You get a brand new will sent to you. We don't do codicils because we just think they're tatty bits of paper. We'll give you a brand new will, and we can amend your will for you at any point in time. It's not like a rewrite of the will. It's just for like a simple amendment.
Yeah, just adding something new.
Yeah,
that's great. So this is our last question actually now. What is the average cost of making a will? If you're convinced to start a will, you want to write a will, what is the average cost of it?
Yeah, it's really hard to say because a lot of it, a lot of the pricing structure depends on the value of your estate. So if you've got an inheritance tax risk, and your estate's a certain value, then you could potentially be looking at wills and trusts, etc., which will be more expensive than somebody who hasn't got an inheritance tax risk. But the one thing I just want to be really clear, and we talked about this as well, is that the will guys. So our offer to Plainsaver to all the members is that a basic will we'll do for anybody for free. We'll do 50% for a will for a partner. Anything in addition, so like trusts, powers of attorney, etc., they are all chargeable services. But this is a similar thing that we do this with a lot of businesses, organisations, the NHS, Blue Light Card, armed services as well. We do that, so we've got the covenant with them as well that you guys have. So this is our commitment to you. So it will be competitive, but a lot of it is dependent on the value of the estate.
That's great. So you've heard it here first. If you are a staff member or you are a member of Plainsaver, you will be able to get a free basic will from the Will Guys. It's coming soon, and we'll let you know when that is available for you guys. So we do have some pre-submitted questions from the audience, if you don't mind me going through them.
No.
So that's great. So one of the first questions, and this is the time, if you have any questions, if this has spurred anything, leave a comment and I will read your questions in the chat. And if you wouldn't mind. So one of the first questions is, what happens, and we actually covered it a little bit, what happens to my will if I get married and if I get divorced?
Okay, so if you get married, your will be invalid.
It become invalid?
Yeah, so marriage effectively revokes the existing will. So if you've got a couple and so you were you wrote your will and then you got married 5 years later, effectively your existing will is no longer legally binding. It doesn't need a brand new will, it just needs an amendment to show that you're married. So it's not like you've got to start the process again, it's just a simple amendment. If you are a couple and you have an intention to marry, i.e. you've got a date set in the diary to get married in the following summer, then we can put the intention to marry clause in and the date so that when you get married, the will still remains valid.
Oh, there you go.
Okay, so that's what you do. So that's the marriage side. Divorce, absolutely nothing. It doesn't revoke a will at all. So if you are, if anybody is either getting divorced or divorced and they have an existing will and they want to speak to me, they should do, because
if you get married, it invalidates the will, but if you get divorced, it's still valid. Unless
you amend it.
That doesn't make sense to me.
No.
But
But they say the law is an arse, and you know, there are things that are
Am I
staggering.
allowed to quote that?
Yeah, you are.
There you go. The government is yeah. So another one of the questions here is, oh, can I leave my digital assets like social media accounts or crypto in my will?
So yes, you can. So crypto, you know, there's a value of those assets, and they can be left in the will. Social media accounts, so it's a bit of a difficult one, because if you want somebody to be able to access your social media accounts, you could effectively write a document and you could have your passwords. But obviously, I can't say that you should definitely do that, because it might be some kind of, like, you know, you might not be able to access somebody's account with a different password. I know some social media accounts will effectively say if somebody's no longer here, it shuts down. Okay, so
it's a difficult one.
Yeah, it's a difficult one. There's also not a tangible value of a social media account. You see, it's a personal thing.
Indeed.
So, you know, if you write a will and you leave a document giving some advice to your executors on it, fine. But, you know,
there aren't really any like legislations around what to do with social media accounts at the moment. It's just
choose. Yeah, it's difficult.
Yeah.
But yeah, I mean, anything with like a tangible value is going to get distributed. Like crypto is absolutely fine. But digital assets can be included in wills.
Yeah. So if you are a content creator and you have 1 million followers, you can leave your password in your will for someone to deal with that, and pass on a message as well, right? So how do I make sure? Maybe this is impossible, but how do I make sure my family won't have problems with my will?
Okay, so try to sort of like think about that from two angles, really. So problems with your will. So, you know, make sure it's written properly, stored properly, capable people as executors and trustees, fair distribution of the assets, i.e., you know, it's reasonable what you want to do. Yeah, like I said, stored safely, etc. People won't have problems with the will when it's signed, witnessed. There, it's like, you know, it details exactly what you want to do. It's very, very clear. There's no ambiguity. Okay. Now, if the question is about what if I nominated my children or my husband to be my executor and they were struggling with it, go back to my point earlier. You can appoint professionals to deal with it and get it over the line if they needed to do that. The second thing is, if this question's about problems with the will because it could be a family disagreement, and maybe this is because there's an estrangement from one of the children, or their share is going to be less than the other. If there's a legitimate reason, then we'll put detailed notes. There'll be detailed notes on the file anyway as to the reasons why, which can be produced at any point in time if anyone challenges it.
So you can't lie after.
No, and there's something that we do. We do something called a will clarity statement, which effectively is us saying that the client had capacity, they knew what they were doing, they understood everything, etc. So all of these things, if somebody isn't happy with what's happened, when you produce these documents, it's like very clear that there's reasoning as to why things have happened. So I hope that answers the question.
But this one is a little bit more personal here. Someone's got a bit in depth.
Yeah.
So if a property is left to 2 children by a parent in an equal split, what happens if the parent outlives one of the children? Does the share of the property revert directly to the remaining sibling, or does it pass to the beneficiaries or descendants of the sibling who passed away before the parent? And the other issue here is that the parent is no longer deemed to have the mental capacity to amend their will.
Okay, fine. So to cover the first point, every will we write will be set up so that if one of the children predeceased their parents, their share would go to their children if they had any. And if they don't have any children, it would then default to the surviving sibling. So I think the other point means that the other issue is if the parent is no longer deemed to have the mental capacity. So I'm assuming the person who submits this question means, because if they had no longer got capacity, they can't amend it to include the grandchildren, but it would automatically be done from the outset anyway.
Okay, there you go.
It's all about bloodline planning. It would always be the children of the child. So it'd be like parent giving it to passing it to their son, and it would be then the son's children, not the son's beneficiaries, i.e. it wouldn't include his partner, it would be his children's bloodline planning.
That makes sense to me.
Yeah.
So we've got one more question here, and then I'll go to the chat. Is a will a written letter or is it a contract? Like in my mind, I'm imagining, hi, like if you're reading this, it's too late or something like that.
I mean, it's a legally binding document, so it can only be broken, i.e. it can only be amended if the testator, i.e. the person that's written the will, wants to amend it and has the capacity to do so, or if an amendment was required after that person's deceased, then there can be something called a deed of variation to change the will. And that's done sometimes if, say, the will's not tax efficient or something's come up that changed the situation, then all parties can agree to a deed of variation. But yes, it's not just a letter.
You can't put emojis in it.
Sounds a bit, but yeah, a legally binding document.
I see. Yeah. So now let's go.
You can't put emojis.
You never know.
Yeah.
I just throw people off here with this webinar a little bit. Do you have a Samsung?
No.
No. I've had an iPhone for the past 10 years. I do not know how to use one of those things. Thank you so much. Thank you. Okay, so let's go to the questions in the chat. Right. So let's go from the top here. Could anyone ever contest who gets what if they don't? Or if they don't agree with your choices, can anyone contest?
Only if they've got those people I talked about, really, either children, so children of the estate,
or spouses.
Yeah, spouses, etc., partners.
Yeah. Oh, that makes sense.
Yeah.
So
no one else has got a right to, like say for example, if you're alluding to it, like, what if I didn't, could my estranged brother contest? No,
it has to be
someone
blood-related, bloodline planning.
Yeah, it is all about children, spouses, and partners who live in for more than 2 years.
Yeah. So how long does it take to write your first will or first draft of a will?
Good question. So I think sometimes people are put off the idea of writing wills because they feel it's a really lengthy process. So we realise that people have got busy lives and they don't want to be speaking about this kind of thing for too long. So how it works with us is client books in, they're added to our CRM, they get a pre-appointment form to fill out. So we get information before, so we know about the value of the assets, names of the children, their addresses, etc. So we've got all that detail.
Okay. So
by the time we do the will, we're in a good place to advise. We know a bit about it. We've taken the first 30 minutes of the appointment down already. Appointment 1 takes about 45 minutes to an hour, and then there might be a follow-up appointment just to confirm what option they want to go through. So I will talk about options in the first appointment. Sometimes clients will go, I'd like to just consider that. Then we'll rebook, finalise the next week, done. So I would say both meetings combined, you're looking at an hour and a half.
An hour and a half.
Yeah, and then fill out the form. So, it's kind of like, it's under 2 hours back to back.
And that's all your assets sorted out for the future.
Yeah.
2 hours, but for your whole future, that's really great. So if you store it yourself and it goes missing, is there any way to prove it exists?
No. So the wills are all registered to the National Will Register. So if a will goes missing, somebody can trace it back. The will guys wrote it. Then they can contact the will guys and go, is it stored with you? I'm like, no. So then it's the case of, okay, now we need to find it. And if you can't find it, if the existing will disappears, it's...
So it really is just a printed piece of paper, and it's that one piece
with
of
wet
paper.
ink on it. It has to be that one.
It has to be that one.
Yeah. So if you took clients often say to us, "Well, if I store it with you, do we get a copy?" I'm like, no, because legal precedent would say no, because in history there's been more than 2 copies of a will and one slightly different than the other because someone's amended it. And I'm not saying that's going to happen in all families, but this is why you don't do that. So they'll go, okay, well, I'll photocopy it in case something happened to the other one. I'm like, it won't because we're storing it, but 2, a photocopy doesn't make any, it's pointless.
Yeah. Wait, so only the one will. What happens What happens if I forgot to include an asset in my will?
It's absolutely fine. You don't itemize the assets within a will. Your will is going to change all the time because what you have in your, the equity, the property, the cash in your bank, your performance of your ISAs, that's going to change all the time, constantly changing. So we don't itemize it. So we'll have the details of the assets at the point of time we wrote the will. Then if assets change over time and it needs an adjustment to the will, fine. But most wills that we write for people will cover growth in assets. And the only change really is if people start to get inheritance tax issues, and then we might change the advice slightly.
So it's basically impossible to leave something out of a will.
Yeah.
There you go. So another question here. How often should a will be reviewed or updated?
Well, a review should be reviewed every couple of years. Yeah, every 2 years check.
2 years?
Yeah, we review wills with clients as well. So it's like, when we write wills to people, the door doesn't shut, and that's the last time you'll ever hear from us. And I was saying to you earlier, when you've written a will for someone, it's quite a personal thing.
Yeah.
And they shared a lot of information with you, and you've gone into quite a bit of detail over the time. By the time the appointment finishes, I'll say to all my clients that, if anything changes, you have all my details. You can send me a message, a WhatsApp, an email, call me. I'm always going to be your advisor. And, that's how my relationship is with my clients. People go, "Oh, Keith, this has happened. Do I need to do anything?" Like, no, not really. So, yeah, absolutely, it can be changed. And it only requires amending if, there is something significant that requires it.
So that actually does lead me to my own question here.
Yeah.
Thank you for sparing my question. Is there specific moments in your life you'd recommend this is the time you need to make a change to your will?
Yeah, children.
Children?
Absolutely huge, because obviously you need to name them.
And marriage, we covered that.
Yeah, marriage, children, changing property, moving house, etc., moving address, deaths of executors potentially, or fallouts with anybody. You might want to change guardians as time goes on. So, just they're the triggers really.
Thank you for that. So, what are the key considerations when writing a will for someone with dependents who have disabilities or additional care needs?
Yeah, so the things to consider are, trusts really help in this situation. So, if you wrote a basic will and you said everything's going to go to my husband and then or wife or partner, and then both of us gone, it will go to the kids. They'll just get everything of yours at whether they're 18 or over, they'll get it there and then. And if they're young minors, 10, 12 years old, they'll get it as soon as they're 18. So, if you've got a child who has disabilities or is dependent on certain things, then you might not want them getting everything in their bank account, because obviously, if they're having, say, if they get some form of benefits, then they can means test that and say, well, actually, we're not going to give you that now. So what you do is you put the assets into trust, you nominate trustees, and they're the people that are responsible for distributing the money to the beneficiaries. So they can, and that money held in trust them can't be means tested for maybe care or treatment or benefits that they get, you see. So they can retain their benefits.
Yeah.
And you've got them responsible, people who can be responsible for making sure that, money's distributed to them in a sensible fashion.
Oh, that's really great. I hope that answers your question. So we've got a few questions actually. What are the risks of using a DIY will kit instead of a professional will writing service?
Yeah, I mean, it's not signed properly, not witnessed properly, not protected your assets in the way that you would have done if you'd have taken advice, i.e., if you do a DIY will, you are not going to be protecting your assets from care home fees when you're older, from the risk of kids frittering it away, the risk of somebody passing away and a surviving partner remarrying, and then this risk of inheritance going to somebody else's kids. You see, all these things are never going to be covered under a DIY will, because there's going to be no compensation. to be had about those things.
So there you go. That's a few reasons there, yeah. So how does writing a will interact with life insurance policies and pensions?
Very good question. I like this one. So life insurance is really important. So life insurance, when you take out a life insurance policy, your advisor should always put your life insurance policy in a life insurance trust at the time you set the policy up. Because what that means is, if your policy is in a life insurance trust, your life insurance will avoid probate. It won't form part of your estate. It will effectively pay out to your beneficiaries relatively quickly, matter of weeks, months, a couple of months or a few weeks. If your life insurance policy isn't written in a life insurance trust, then it will add to the value of your estate. It will be one of those assets that need to go through probate. Could take a year to pay out to your beneficiary. So if you're two partners and you both own a property and you're both contributing to the mortgage and you've both got separate insurance policies and they're not written in a life insurance trust, one of you could pass away and you might want your partner to have that money quickly to pay off the mortgage or to bring up the kids. But if it's not written in a life insurance trust, it's going to take about a year to pay out. Now, a good advisor should do this from the outset. It takes about 10 or 15 minutes to do. It's a document that you get from the life insurance company. Should be no charge for it. Very, very simple piece of admin. And I can help with all of this as well.
Okay. And what about pensions? So as you mentioned that.
So at this point in time, pensions fall outside of the estate. So pensions aren't, taken into consideration in terms of the value of your assets. The government have mooted that this is all going to change come April 27. Who knows what's going to happen in 2 years, because 2 years is a long time. But potentially in the future, pensions might be included in the value of estates. But we don't know this for certain, and we can only deal with the circumstances as they exist. But rest assured that if something happens in 2 years and pensions are included, we will have to look at a lot of the work that we've done for people just to check whether we need to make changes, etc.
So, do cohabitating partners have the same rights as married couples when it comes to inheritance or dividends?
No, they don't. So, cohabiting partners don't. So, I'll give you the worst case scenario. So, let's just say you've got two partners living together and they've been living together for 10 years. And let's just say the house is in the wife's name. Now, if they haven't got a will and that wife passes away, wife passes away, that property will go to her next of kin. So if they've got children, it will go to the children. If they've not got children, it will go to her mum and dad. And if her mum and dad aren't there, it will go to her brothers. So effectively, you'd have the risk that that partner will be homeless.
I see. Yeah, that's massive.
Yeah. So, if there are no rights. From an inheritance tax perspective, it's I'm not saying that you should go and get married because it's efficient from inheritance tax, but there aren't the same benefits and the same tax efficiencies that you get from being cohabiting rather than being married. So yes, it's huge, especially if you've got assets that you want your partner to have and you're not married and you live together, then you have to write a will, otherwise it won't go to them.
Oh, there you go. That's really going to be a piece of advice there. So is there any circumstance where a will change or an update can be invalid?
A will change or an update being invalid. That all depends on the duty of care of the professional that you're using. So a will update, if you're updating a will, if you're updating a will, say for example, for a client that actually hasn't got the capacity to do a will, to update their will, then there is every right for it to be invalid.
I see.
If the update it's not going to really, that would invalidate the will. That's probably the only real reason I can think of why an amendment would cause a will to be invalidated.
I see, yeah. Yeah, it's quite a niche question.
Yeah.
So if the person is incapable of changing the will, will the power of attorney take effect?
if I know what this question, so if you've got a client that lost capacity and they've got so the client's lost capacity, they've got powers of attorney in place, so they've got people who can deal with their affairs if they no longer have capacity. Yeah. Those powers of attorney won't be able to amend the will. They'll be able to deal with all their property and their financial affairs and their health and welfare, but they wouldn't be able to amend the will itself.
The will is in stone.
Yeah.
Okay. Is there a central database or registry where wills are stored, or do families just need to know where to find them?
Yeah, so there isn't a central database, but there's a national will register.
Yeah.
So our wills are registered on the national will register. So if you know somebody, you can search on the national will register and you can find out who wrote the will, etc. Yeah.
And where it's stored.
Yeah. So but obviously, yeah, you don't have to do that. We do that because it's the right thing to do.
Oh, I see. So that's something you should be conscious of as well when you're writing will.
I would say so. Yeah.
Family know.
Yeah.
Where to find it.
Yeah.
Yes, that's actually a continuation of this question. What's the best way to ensure that executors and family members know where a will is stored without compromising its security?
Yeah, great question as well. So ultimately, so this is where storage with us is going to be key. Because if you want, I mean, to be fair, if you're nominating people as executors in a will, there's going to be elements of it you probably, you might have discussed with them. But if you haven't and you've nominated and you don't necessarily want them privy to the detail of the will, then store it with us. And then the communication that happens with the will is, I write will for somebody. We get to the stage where we're writing the will. I will then say to my clients, I'm going to speak to your executors to have a courtesy conversation with them, see if they've got any questions for me. So they'll get an introduction to Keith and the will guys. If the will's stored with us, they will get then contacted from our office to say, oh, by the way, the will's now in storage. If you need to retrieve the will from our storage facility, this is the process you need to go through. So there's plenty of communication done from sort of 2 different avenues whilst we go through the process.
I see. Okay. There you go. Another question here. Are handwritten or video wills legally valid in the UK?
Handwritten wills can be legally valid. So if you handwrote a will, got it signed properly, it can be valid. Video, no, unless you are armed services, I believe. Armed forces. Armed forces can do video wills, I'm sure, because if they're just about to go on, be deployed somewhere, say it's like a war situation, they suddenly they've got to go, they can do it via video or verbal.
Oh, there you go.
Yeah. And anybody in the military, they can write wills from 16. So they only put that, it's 18 for everyone else, apart from military, 16 by nature of, we've always done work with the military. Director of our business, husband was in the military. We've always offered what we do for what we've offered to the membership of Plain Saving for the military as well.
Yeah, we do have a lot of military members, so it's good for them to know. So if you move to another country, do you need to update your will, or is it still valid internationally?
No, not necessarily. So it depends what you've got. So
wait, no, it's not valid internationally?
Let me talk about it. So it depends. So if you've got, so if you move to Spain or France, your English will, we can add a foreign property clause in there if you've moved to Spanish property, French property, Italian property, Portuguese, etc. So we could adjust the English will to cover the foreign overseas assets.
Okay.
So that can be done. So there's basically it's called a Brussels Treaty clause. It was from the EU days. So it just meant that, if you own property in Spain or Portugal or Italy or any of those countries, France, you could write a will in the UK that could cover those assets. If you got rid of the assets in the UK, then I'd be looking at writing a will in that new will in the country, to be honest with you. Also, I have heard that people say, it's quite difficult with property, etc. And sometimes the authorities might go, don't care about your English will, still want one written in Spain or France, etc. Sometimes you just got to deal with it. But in answer, in theory, yes, it can.
But best to be safe.
Yeah, sometimes.
Sometime
Yeah.
at
But
your own
I
risk.
would say if you're going to go and, if you've sold your English assets and you're moving out to Spain, go and get a will in Spain. If you've got property out in Spain, but you've still got assets in England, have the English will to cover the overseas assets.
There you go. That. So are wills public documents after death, or can they remain private?
Oh, it's a good question. I'm sure after a certain period of time, I'm sure that there is visibility to the public at a point in time.
Really?
But I'm not 100. I'll be absolutely honest with you. I'm not 100% sure, because I'm sure when the Queen passed away, there was they said that this will never be available to the public domain. I think what you can see is, I think you don't necessarily see the full document, but you can see the executive, the beneficiaries of the estate. So
I see.
I do know the answer in that you will be able to see the key elements of it, like who benefited from it, but you won't be able to see like an actual full copy of the will itself.
Yeah.
But I don't know the time frame where that will become access to the public.
Well, we'll try follow this up with the answer to that if that's possible.
Yeah.
So if we cannot find a beneficiary and we suspect they have died, what should the executor do?
If you can't find a beneficiary, you think that they've died, then it will fall down effectively. It would then refer to the laws of intestacy, as in, okay, who was that beneficiary and who's their next of kin?
I see.
Yeah.
So this is it's the last question, unless you guys have any more questions. If a beneficiary named in a will dies before the person who made the will, what happens to their share if the will isn't updated?
Okay. Then again, so if there's no children, if they die, again, that will go to the point there. If they've got kids, it will go to their grandchildren.
Yeah.
If they don't have any children, it will then go through the rules of intestacy again and look for surviving beneficiaries, basically.
Yeah, there you go. Well, thank you very much. I don't think we have any more questions.
Welcome.
So yeah, thank you very much for that. Yeah, it's been really great. I hope you guys have learned a lot about wills and know why you guys need to get a will. So yeah, thank you very much, Keith. And we'll see you guys next month for our next webinar about money first aid. So
lovely. Thank you very much.
And thank you, Keith, again.
Yes, thanks.
Thanks. Bye, guys.